Well, hello everybody. My name's Phil Warford and I'm the Managing Director of Renaissance Legal. We are a very specialised firm based in Brighton, but we cover the whole of the South East and London. And we work predominantly with people who are vulnerable, elderly and disabled to make sure that the right sort of protection is in place. As Eleanor said, Subi's done me a fantastic favour. He's talked about probably 3 minutes of my talk, which I can skip through at the beginning and hopefully help you catch up a bit. But I've been invited along today to talk to you about 3 different things, kind of explaining how they work together, what they are, how you can integrate them into the planning process, also the legalities of some of them, and the sort of things that you need to think about when you're broaching this subject with your clients. So we've got the advanced care plan, or the advanced care planning process, advanced decisions we're going to talk about, and we're going to talk about lasting powers of attorney. I'm also going to give you some different names for these things, because something that's come up this morning when I've been talking to people is that I think we all sometimes call things different names, and actually, you know, the law doesn't help, the press doesn't help, because they also change the names. They're a bit interchangeable. So I'm going to give you a few different variations on what these things are called. So starting off with the advanced care plan, and this is where Subi helped me out enormously. So he's now introduced this concept to you. I, as a lawyer, was actually under the misunderstanding that you all did it anyway. I just presumed this was part of the package. This was what was done when there was initial dementia diagnosis, but obviously not. And that probably is a little bit concerning to me, because I just thought that knowledge was out there. But the planning process is where you are looking at and talking with your clients about what their concerns are, their wishes, their values, their fears, all in the context of this diagnosis, and putting together a plan which says all of this. And the plan itself is going to change over a period of time. We all change our minds. But if you can do it at the outset, when the diagnosis comes about, if you can involve the family, it's going to be really helpful. And as Subi has sort of indicated, you know, this is something which is core to what goes on with the family. And actually, from my point of view, this is something that's going to help me enormously to take you on to the next kind of more legal documents. There is no prescribed form. I'd be really interested to see Subi's form. It looks fantastic. I'm sure people have their own way of dealing with it. And in terms of the legal standing, it's not legally binding, or not yet. You know, it might do in future, but at the moment it's not legally binding. It is obviously very persuasive because it comes into the best interest decision making. So when you're talking to your clients about this, because it is about their wishes, healthcare professionals are going to be guided by this advanced care plan, if at all possible. And how does it work in practice? As Subi said, you know, it's got to be the right person, the right level of communication at the right time. And that person has to have the right sort of knowledge about how this dementia diagnosis is going to continue, how the individual is going to find their pathway through the dementia care. What's important with this, to differentiate it from other documents that I'm going to talk to you about in a moment, is that with this, because it's an expression of a wish, if you like, you can say whatever you want in it. You can actually say, I don't want this sort of treatment. You can say, I do want this sort of treatment. So it can be positive and negative. And that's very important with this, because we are looking at clients' needs and their feelings and their wishes. You know, it can be whatever they feel is appropriate to put in this type of document. Advanced care plans, just to give you some different names for how these are going to be dealt with, unfortunately. Advanced care plans, sometimes called statements of wishes and preferences, also sometimes called an advanced statement. So we see in the Mental Capacity Act quite a lot of reference to advanced statements, and this kind of falls into that bracket. It is statements which are not legally binding, but are hugely important because they do give all of these underlying factors, underlying thoughts and wishes, which are very individual. So, moving on more to the legal documents, the first thing we've got here is the advanced decision. So this is where we start getting more involved. Advanced decision is what the in sort of pre Mental Capacity Act days, it was called an advanced directive, or you might have heard of the term living will. all sort of a bit more archaic now, and it is now called an advance decision. And what that is an express refusal of medical treatment. Now, what's important with an advance decision is that it's done with the diagnosis in mind, with the factors in mind that you are going to be able to guide the client to think about in terms of what is the treatment that is anticipated with this diagnosis. So you look at the type of treatment that is going to be anticipated. The client then talks to the healthcare professionals and maybe to the lawyers to try and get in place a document that reflects what they don't want to happen. So this is a negative document. This is a document that says, I do not want this treatment. And that's where it's very different to the advanced care plan, because that can say, I'd prefer to have this treatment. So advanced decision is always a negative. It's always a refusal. In terms of creating it, unfortunately, it can be created orally. Now, as we all know, saying something to each of you might be perceived slightly differently, and lawyers earn lots of money from families who fall out because of oral statements made. If there is a refusal for life-sustaining treatment, then it does have to be in writing. But I would certainly advocate to everybody, if you're doing an advanced decision, it's going to be in writing, because then it's clear for everybody. As with the advanced care plan, an advanced decision ought to be registered everywhere that the client goes. So with your GP, with the hospital, wherever it goes, hopefully I'm not stealing anyone's thunder, but maybe in the bag that we're all going to get at the end of the day. But it is something which goes to the core of the treatment this client doesn't want to have. And it's that anticipation about future treatment, which again, like the advanced care plan, is something that may evolve with the client. So they might do one today when they get their diagnosis, or they might do that in 6 months or a year, but they might also review it over a period of time as things are going to develop in dementia care in any case, so treatments are going to develop. So this is something that you would do and maybe keep under review. In terms of its legal standing, it is legally binding. It has now got statutory effect under the Mental Capacity Act 2005. Prior to that, common law cases had come about to say what types of advance directives and living wills, those old terms, what we could follow. But now it's statutory, which means that there is a massive amount of guidance out there from the law to say what is acceptable and what is not. It enables us lawyers to sue healthcare professionals for not following them where they are appropriately put in place. And how they work in practice. I mean, from my point of view, clients come to me in two cases. One is quite funny. They come to us when they've seen a soap opera and the soap opera star has had something like an advanced decision. So they come to us a bit half-cocked, saying, I saw this last night in EastEnders. I want one of these. I've got to have one of these. That's not really the ideal situation. The ideal situation for us is that they've had a diagnosis, they've spoken to the healthcare professional or the social care professional, and they've got an understanding of what they need. And then from our point of view, the ideal answer really is to work with you, is for the partnership. You know, partnership is something that's been talked about already this morning. I'm sure it's going to keep coming out all today. For lawyers and healthcare professionals, social care professionals to work together. We bring one element of knowledge, you bring something else. You know, we don't really cross over into what you do. Equally, you know, we're here to guide the legal side of things. So actually, we can get it together as a partnership, get the right document in place for the client. So, having got our heads a bit more straighter about advanced care plans, which is our wishes, which is the things we can say we want or don't want, the advanced decision, which is our refusal, saying we don't want to have this treatment or we don't want to have life-sustaining treatment, and that is legally binding. Excuse me. We come on to lasting powers of attorney. Now, some of you might already have this document yourself. Some of you might have heard about it. And a lasting power of attorney is a document whereby you can delegate authority to someone to act on your behalf in relation to the decisions that you could otherwise take for yourself. There are two types of lasting power of attorney. There is one dealing with finances, which is kind of a bit irrelevant for today, but the one we're focusing on is the one that deals with health and welfare. And that is decisions about your day-to-day care, where you receive that care, who comes and visits you. You know, it enables someone to take on that liaison role. Now, with the lasting power of attorney, your delegation of your authority to your attorneys will only come into effect properly when you lack capacity to make those decisions for yourself. So a lot of people have a lot of fears about lasting power of attorney, saying, oh my God, you know, once I put it in place, they can go and stick me in a home and I'm not going to have any say. That's not appropriate, that's not correct. I mean, that's factually, legally not correct. With a health and welfare lasting power of attorney, your attorneys can only act for you when you lose capacity to make decisions for yourself. So actually, it is a fantastically helpful document. There is a prescribed form for this one. You have to follow the prescribed form. If you don't follow the prescribed form, then it can get kicked out. What you want to happen can be struck off. And I'll talk you through the process just in a second and who would actually do that. In terms of the legal effect of these documents, they are legally binding. They were brought into effect by the Mental Capacity Act of 2005. They were so complex that it took 2 years for them actually to come into operational effect. Not until October 2007 did they actually come into operational effect. But they are now binding. They've gone through a couple of changes in terms of the forms used, and in April this year they're going to become digital. How good or not that is still awaits to be seen. I fear that it's going to be something which is going to be one of those teething problems, but actually things are progressing. So this is something that's going to stay around with us for quite some time. And how they work in practice. I mean, obviously this is a legal document. So quite often people will come to lawyers to get these documents in place. They don't have to, as with advanced decisions and as with advanced care plans, individuals can do these documents themselves. Lasting powers of attorney forms are downloadable from the internet, like advanced decisions are, but actually where healthcare providers and where lawyers can work together to add value is to go back to this core that we're saying, you've got a diagnosis. This is what we think is going to happen on your pathway through the dementia. And therefore, what sorts of thing do we specifically need to think about that's going to happen to you that we can put in this document? And that's where we can work together to add some value to the client. If it's just a straightforward document, then, we're talking about saving money earlier as well. The client can do it themselves. Come to us and work together with us when it's something which is more like the dementia diagnosis, which is going to be desperately important for people. Okay, so we hopefully, with my explanation, has sort of got clear in our heads. Advanced care plans, that's our wishes. That can be what we want to happen or what we don't want to happen. Advanced decision is our negative. It's the refusal of treatment, refusal of life-sustaining treatment. And the lasting power of attorney is where we're going to delegate authority to someone to take those decisions on our behalf. So 3 separate things. What's best for your client? 4 points here. I think to start with, there is no right or wrong for anything. Because everybody's individual, we're all individuals, there is no right or wrong. These 3 documents can be changed at any stage when people still have capacity. So, it's an evolving type of thing. But I've put here 4 things that need to be thought about: capacity, needs, timing, and also costs. So let's start with capacity. Capacity from a lawyer's point of view is quite core and key to what we do. We often get a telephone call from a son or a daughter to say, Mum has been diagnosed with dementia. Can you come and see her immediately? We need to get something sorted out. The Law Society are very strict about this. Our first answer to that is, tell me a bit more about your mum. When was the diagnosis of dementia? What can and can't she do? Because from our point of view, there is a massive capacity issue with these documents. So with Advanced Care Plan, what I hope you're going to do after today is obviously get that in place at phase 2, phase 3, where there is that initial diagnosis. Excuse me. So the Advanced Care Plan is not going to have a capacity issue at all. Also, because it's not legally binding, we can be a bit more relaxed about capacity. With an advanced decision, capacity is an issue. This is a legally binding document. And what the Mental Capacity Act says is that we have to look at, that there's not, in the Mental Capacity Act, there's not a statement to say a client has capacity if they tick all of these boxes. What the Mental Capacity Act says is that we need to look at the timing, what the client can do, everything in sort of isolation for this particular transaction. So it might be, the time of day, when the drugs kick in, something I was talking to a lady about this morning, communication levels, all of those things can affect capacity. So the Mental Capacity Act, with the advanced decision, is saying, look at what the client can do. If the client can do it, great, go ahead. If the client can't do it, we need to think about other options. There is the functional and the diagnostic tests in the Mental Capacity Act, which you have to look at with advanced decisions as well, if necessary. With the lasting power of attorney, because we're kind of ramping up with each of these three documents, with the lasting power of attorney, we go one stage further. So we've got the Mental Capacity Act saying we need to just look at whether the client can do this type of thing at this type of time in these circumstances, but then we need to go one step further. And it's not unfortunate, but we need to go one step further, which makes capacity even more important. And we say that, can the client understand what the document does, the extent of the document? Can the client understand that once the attorneys are in place, they can act on behalf of the client? And can the client understand that when they lose capacity, the document is irrevocable, it stays, those attorneys can make decisions for you? So capacity, from our point of view, is going to be a massive issue. Needs of the client, we go back to the core principle of the Mental Capacity Act. Everything we do these days has to be in someone's best interests. So what is in your client's best interests? Kind of in the eye of the beholder, isn't it? It's like the word reasonable. What I think is reasonable for my glass of wine on a Friday night might be very different to what you lot think is reasonable for your glass of wine on a Friday night. Very, very different principles. So best interest is rather in the eye of the beholder. But actually, I always think if you are trying your best and doing your best and passing on as much information as you possibly can, then you've got to be on the right side of things. Time constraints, something we're playing with today, Eleanor, time constraints. So advanced care planning. I don't know, because I haven't really chatted to you guys about how long you think the process takes, but with advanced care planning and getting to an advanced care plan, personally, if it was me, I would like that process to take a little bit of time. Because I've just had a diagnosis of dementia, I need time to get my head around it. I need time for my family to get their head around it and what they are going to be facing in their life-changing process with this. So I would think with an advanced care plan, it might take a couple of months to go through that, and it might take a few get-togethers. It can be done, there's no reason why it can't be done immediately. There's nothing to say that it can't be done immediately, but I think when we're looking at timing, it's something which is a bit of a process. In terms of the advanced decision, again, I think it's the same kind of process. We need to think about what medical treatment might we be having in the future, and therefore what type of care do we not want to have? What type of treatment do we not want to have? So I think with an advanced decision, there is a time sort of imposed upon us just because we need to go through this thought process. If someone did phone me up today and said, I saw it on EastEnders last night, can I do an advanced decision? There is no reason why I can't book a client in this afternoon, see them and do the document immediately. And the same with advanced care plans. There's no reason why it can't be done immediately, but I think it's a process that it ought to take time. With lasting powers of attorney, that's where we get into slightly different territory. With a lasting power of attorney, because it's so important, it has to be registered with the Office of the Public Guardian. And the Office of the Public Guardian then have a chance to say, I don't really agree with who your attorneys are, and someone else independently can have a chance to object to who your attorneys are. Now, that registration process was brought into effect specifically by the Mental Capacity Act to give vulnerable people some layer of protection. Because with the old enduring power of attorney system, they were liable to abuse. We never knew how many were out there, how many were being abused, but there were quite a lot of bank accounts that suddenly went from £10,000 to £100 as soon as the enduring power of attorney was in place. With the lasting power of attorney and this registration process, we have to wait a couple of months for it to go through. The ejection period is actually 5 weeks, but actually by the time you've sent the document off and got it back, it is 2 months. So if I saw my client this afternoon, and if I could get it typed up that quickly, we are playing to a 2-month period in any case. So thinking about that and thinking about time constraints, it gives us some indication about what may or may not be appropriate to the client. And costs. We talked about costs earlier on. Costs is a factor. You guys working with the client, talking about planning, advanced care plans, I'd imagine there's no cost involved in that. That's free, that's zero. And when you review them, I would imagine, again, that's part of your process. Again, that could be free. Advanced decisions, people don't need to see a lawyer to do them. People can do them themselves. I would be a little bit worried, unless they had some help on the way. But in theory, advanced decisions are free. You register them with your DP and with your hospital, but potentially they are free. You can do them yourselves. Lawyers will charge a couple of £100 to do them, maybe more depending on how complex they are. Lasting powers of attorney, again, potentially are free. You can do them yourselves. There are forms you can download from the internet, from the Office of the Public Guardian. But if someone's coming to see a lawyer, then it's going to be a little bit more expensive because we're spending more time doing this document. So cost does come into it. Also, when you go through this registration process with the Office of the Public Guardian, there is, for most people, a fee of £130 to register the document. So for some people, we look at all of these issues and say, what's best for you? And this is where working in partnership, where lawyers working with health and social care providers can actually get the best results for the client. So I'm just going to quickly, hopefully, give you some guidance about what you may be thinking of and what might help your clients. And I've put this in rather the wrong order. So I'm going to start with a long-term need. So let's take our initial diagnosis of dementia. We've got a 65-year-old lady, just had the diagnosis of dementia. So end of life is still hopefully quite far away. The diagnosis is still relatively new. It's very mild dementia. Capacity may not be an issue for any of these documents. Timing may not be an issue. Needs of the client, can be whatever. Costs may not be an issue. So with the long-term need, with the initial diagnosis, this is when we can do most for this client. This is when we can act in this client's best interests. And that, for me, is key, because it's not us that gets this level of information that you've got. You are going to be at the forefront of the diagnosis of dementia, hopefully. We don't get told until someone comes to us and says, can you help us with something? And invariably, it's a little bit too late. So long-term need is great. Intermediate need. So say, for example, we've got a 70-year-old client and they have now mild to moderate dementia. Okay, so our first point, like I said, to start with is capacity. Does this client have capacity? Maybe, maybe not. Maybe it's fluctuating. Maybe we need to think about how we get the best out of the client, which is at 9:05 after their cup of coffee and their drugs have kicked in and balanced them out a bit. Maybe they can do all of the documents I've talked about. Maybe they can't. So with an intermediate need, end of life may not be as far away as long term, but it might not be, quite so imperative. And this client might be able to do all these documents. With immediate need, unfortunately, this is where crisis comes into play. And this is often where people come to lawyers to say, not long left. It might be we've got a 75-year-old client and they have maybe moderate to severe dementia. At that stage, capacity is going to be a massive player. Quite possibly, this client can't do the legal documents anymore. So the advanced care plan may be the only option if they can still communicate and they are still cognate in what they're saying for their wishes and concerns. So that's a very, very speedy run-through of 3 types of documents which you may or may not come into contact with, which I hope you will, because it's going to be helpful. The moral of the story, I think, hopefully, is that the sooner we all work together, the better it's going to be for the client. I think over the past few years, there's been an unfortunate breakdown in communications between lawyers and health and social care providers. I don't know why that is. We've got a healthcare provider locally which is now refusing to do mental capacity assessments for us. It's not for us personally, it's because that they say that they can't now get insurance for their specialist consultants to give us this opinion anymore. And we're not medical specialists, so we are going to be looking for help with those sort of capacity type statements. So I think, that there is a lot that we can do together here. We have that legal knowledge, we can give you that backing. You guys have all of the on-the-ground knowledge, which we don't have. So hopefully I'd advocate to you to, work with us and hopefully get the best for the client. Thank you very much.